Hey, good afternoon. Carl Rominger here, 540-0580. Do you have a legal question, legal concern, you want to get it answered here on the air, we will talk about it. You might have saw in the newspaper that there was some kind of large-scale drug bust in central Pennsylvania. And the only thing I'm going to say about it, because I think we're getting involved in one of the cases, it makes me laugh, is a lot of people will be like, well, how many of those clients are you going to get? And I always have to explain, and I just thought it was something that's worth kind of throwing out there so people understand. If you have 19 defendants or 27 defendants or 2 defendants in the same case, as a general rule, each one needs their own attorney. So if you were charged with a friend in a bar fight, because I know you're the type of person that would be out there shooting your mouth off and swinging fists in a bar, or maybe you were just minding your own business when the fight broke out around you, but for whatever reason you and your buddy are being told that you're culpable, you probably can't use the same lawyer because at some point each of you may want to point the finger at the other one, or more importantly, Shane, I can't see anything on the screen here. More importantly, you might want to point the finger at the other guy to get a deal yourself, or maybe he's your best friend, you never would, but the lawyer still has to be able to counsel you on that adequately. So there's an inherent conflict there. 540-0580. Dan, you're on the air.
Hi, Carl. Thanks for taking my call. Relative of mine had 2 DUIs within a 6-month period, and that was about 3 years ago. He served some brief stints in jail and was able to get his license back about a year and a half ago. Has not done so yet. And the question that we have for you, there was a requirement for the installation of an interlock system for 1 year after getting his license back.
Okay.
If he hasn't had his license back in over a year and a half, is that requirement still present that that interlock be installed once the person does get their license back?
Yes, I think if I remember it right, just off the top of my head, if you're not going to get the interlock device, then you have to do an additional period of suspension.
Okay.
And you have to kind of let PennDOT know that's your plan. So I think he has to file some paperwork and basically say, keep me suspended. I'm not going to drive during the interlock period, but I'm not going to get an interlock. So I'm not sure if he has credit or not off the top of my head. But
okay.
I know that at a certain point, you can get a regular license back. You're eligible during that other phase for the interlock license.
Yes, sir. Okay. Well, thanks a lot, Carl.
All right, that's the best answer I got off the top of my head.
Appreciate it.
Let's see, who's next? Rick.
Call Mom and tell her to listen to 580. WHP.
Yeah, Rick.
Hello?
Yeah, you're on the air.
Hi. Yes.
You're on the air. You're on the air, Rick.
Yeah, my wife and I are both in our late 70s, and I haven't had a raise in my pension in 20 years, and the cost of living and some debt that we have, we're struggling to get along financially, and we're drawing down on our savings, which isn't going to last forever.
Right.
And we don't want to file for bankruptcy, but and I don't even know what was involved in that. But we get these letters in the mail from these companies that are going to cut our credit card debt in half and that kind of thing. Is there any advice you can give us as to how we might proceed?
Yeah, most of those companies, I'm not going to say they're not reputable, but that's a service you could get similarly by simply going to see a bankruptcy attorney, for instance, because what the bankruptcy attorney can do, and we do this in our office, a lot of times we look at what you have, we kind of figure out how much you owe to who, and then we say to you, okay, here's the bankruptcy and here's how it works. Or sometimes we say, well, let's not go bankrupt. How about I just write letters to a couple of these creditors, get you on reduced payment plans, knock down the interest, and you can afford a monthly payment on it. Now, the only thing that concerned me and what you told me about just in general is if you do have some savings, some of that savings has to be factored in a bankruptcy plan. And if you have too much savings, you're not going to be able to keep it. On the other hand, your pension is generally free and clear of the bankruptcy.
Yeah. Well, we don't really want to file for bankruptcy, and we don't want to. Some people told us just ignore the credit card bills when they come in. And
well, we don't have debtor's prison anymore, so
they'll negotiate with you. I don't know.
Yeah, they will. They will negotiate with you, quite frankly, in many cases. In fact, you might be able to just call them up yourself and say, here's the dealio. I'm going to pay you, X dollars a month from now until forever, and that's how I want to do it, and they may agree with you.
Yeah, I see. Okay.
All right, my friend?
All right, thanks very much.
Let's see, you're listening to WHP 580. I'm Carl Rominger answering your legal questions. John, you're on the air.
Hey, Carl.
Yeah.
How you doing today?
Good, my friend, good.
I got a question. My wife's been on a workers' comp thing for about 5 years. About 5 years. She
Okay.
fell off a ladder, busted her arm up pretty good, had 2 surgeries. They, fused it together. Her arm's shorter than it was. Now the insurance company's saying that they no longer represent the company she works for.
Okay.
And they want her to settle.
Right.
Now, how? And I know a workers' comp attorney is going to want a third of the settlement.
No, we get 20% generally.
Okay, but how do we? They're calling her on the phone saying that they want her to give them amount of money to settle the thing.
Right.
And she told them that she's content with what they're doing because the surgeon, Canada, good doctor, he said that really doing more surgery, she's got limited use of her arm.
Right.
And he's saying that another surgery wouldn't make it any better. It might even make it worse.
Well, in our experience, there's 2 components to workers' compensation awards, okay, or benefits. One is a wage replacement and the other is medical. And so you have to be really careful when you settle those that you adequately take care of the medical component. And I've seen people goof themselves up because they take some lump sum payment and they forget that they're now responsible for all their own future medical bills.
Yeah.
So you can undersettle, and that's an easy way to do it. And that's why an experienced workers' compensation attorney is usually beneficial because we can help you figure out what it is you should be settling for that you're actually going to need. There's one other rub. You're supposed to also be getting it cleared through Medicare because too many people would end up on Medicare or Medicaid later in life with no coverage for a work injury. So they want a medical set-aside trust as well usually, and they have to approve it. And if you don't get it approved through them, you can be in trouble.
Yeah, because they're saying they're not going to require her to resign where she's working because she's working for the same company.
Right.
Under limited conditions because they're aware, she hurt herself there.
Right.
Yeah, I mean, it was a pretty bad injury.
Oh yeah, it sounds like it. Well, listen, it sounds like something that it would be well worth sitting down with a workers' compensation attorney. If she wants to call, I can put her with one and figure out where they want to go from there. Sometimes the advice is to settle. Sometimes it's to just keep collecting your benefit.
Well, they're saying that, well, I guess we'll give you a call and sit down.
I was going to say, who cares what they're saying?
All right. What's it cost to sit down?
It's not going to cost you anything on a personal injury case like that. It's not going to cost you anything to sit down.
All right. We'll give you a call.
All right, my friend.
Thanks, Carl.
Thanks. 540-0580. I'll see you after the break. Hey, welcome back. Carl Rominger here answering your legal questions. For those of you who are joining us for the first time, an attorney here in the mid-state. We practice all around central Pennsylvania. I was in the Lancaster office Friday night meeting with somebody at 5:30 in the afternoon. So as you know, we will work with your schedule. We do weekend appointments as well. Dan.
Yes, hi, Carl. I have a question for you. It's a little detailed, and I hope you give me a chance here. My wife was in an auto accident, and I just went to pick up the car yesterday or the day before, and when they repaired the vehicle, they were supposed to replace the entire exhaust system because it was mangled. When I showed up, they were supposed to replace it with the original parts, which would have been 2 pieces. When I got there, it was welded together in a bunch of different places, and the muffler that they put on was rusty. Now, this is a less than a 2-year-old car, and they claimed that they got the part new from a dealership. I told them to take pictures of it. The claims adjuster looked at them and said, yeah, this is, because I made a fuss about it. they said, no, this wasn't acceptable. They're going to get you new parts and put them on there. But the parts were new. They clearly weren't new. My car's 2 years old. There was no rust on the muffler at all. This muffler had rust all over it, and it was supposedly stored for 2 years in a climate-controlled facility somewhere.
Right.
So I know it seems like they were both working in cahoots to defraud me, and the paperwork says this thing was brand new. So I'm kind of curious. I'm going to take pictures of this, and if during the process I feel like they're not dealing with me in good faith, does this really add some other dimension to the claim?
Well, in terms of the claim for the automobile, yeah, you might have an issue. Now, of course, the parts are supposed to be, as they're pitching them. So if they're not, you may have recourse. The question's proving that. Now, I'm not a parts expert, okay?
Well, no. I guess my point is, with the pictures that they have, and
right.
if they destroy the pictures, that's another thing against them. But I'm going to take pictures of my own before they go back and replace them again. But with these pictures, it would be clear to any layman that this wasn't a new part. I mean, the muffler itself was fixed. There were welds on the muffler, where it was fixed, and they were rusty, like years worth of rust.
Gotcha.
And the body shop said none of the parts were new, and then the claims adjuster, after looking at them, not knowing, that they might have seen an invoice, but how could they really be clear that they weren't getting screwed over?
I was just going to say, They attested that, they absolutely were new. This sounds like an issue. Yeah, this sounds like an issue sometimes where maybe the body shop's billing it as new, charging it as new, and then getting it from a junkyard for a third of the price, maybe? I mean, I don't know.
Right, but I that was my first reaction. That was my first thought. But the claims adjuster left a message on my answer machine, which I'm not going to lose, and they attested to it. It was certainly new. So it's clearly not new.
Did they see it? The claims adjuster actually see them?
They saw the pictures because
okay.
I made the body shop take pictures and send them in to. And when I called the claims adjuster, I said he has pictures, so ask for them.
Now, of course, you're assuming. But do you know for a fact they actually looked at them?
Yes, they told me in the message that they saw the pictures. It was unacceptable, but they made a point to tell me. But the part was brand new, and it's clearly on the diagram. It's supposed to be two pieces. This was put together. And it looked like it was put together by a 2-year-old.
So
it was that bad.
Let's ask this question. Now, it looks like at this point they're going to replace it, right?
They are going to replace it, but what I'm saying is if I find if down the road, I feel in other areas that they're not dealing with me in good faith, how's the judge going to look at that when they tried to defraud me on the auto repair?
Well, it certainly is helpful. I mean, it can be shown. Yeah. Well, let me put it this way: it's kind of cuts both ways, right? If I'm your lawyer, I'm going to argue that shows that they're kind of sloppy, and maybe they're lying. They're going to say,
is there insurance fraud when they put in the document that says that it was a new part that was replaced with a new part, and it was not a new part? And even knowing this, the insurance agent attested to the fact that it was a new part.
But I was going to say, but the flip side is, since they're making it right, they're going to come back in and say, well, to the extent that we did goof up one time, as you can see, whenever we actually do goof up, we try to make it right. So this time around, we must not be goofing up because we're saying everything was done right. So it can kind of cut both ways, the fact that they've caught their mistake, so to speak. But I understand what you're saying is it's such a blatant mistake that it's hard to believe that they have any credibility at that point.
It almost seems as if they're working together to make sure that if they use used parts, they're covering each other's back.
Who picked the body shop?
I actually picked the body shop because I dealt with them before. They're a major car dealership in the Lancaster area that's known for their body work. And I've dealt with them before, but this was so obvious. I mean, when that part came in, if they got it from a dealership and got ripped off, when the part came in, anybody could have looked at that and said, this is not new.
So, Dan, fact that...
It looked worse than the one that was on my vehicle for 2 years.
Dan.
Road salt.
Hey, Dan, we got to wrap this up. But here's the answer. If you hadn't picked the dealership, so to speak, I might be more inclined to believe that there's a cahoots here.
Well, they are an authorized dealer for this company. When I picked them, they were glad to do it because they are an authorized representative for this insurance company.
So there may be a cozy relationship between the adjuster and them. Hopefully they're going to make it right for you. If they don't, you're right. You are into something. All right, brother.
Okay, thank you.
540-0580, 540-0580. If you've got a legal question, call in with it right now. We'll answer it here on the air. You don't often get a chance to get free advice, and obviously I want to make sure you understand that the free advice we give here on the air is just that. It's free, so you get what you pay for. And the reason is we can't get into all the details we would in the office, obviously. Number two, I think generally what you should take from most of these situations is you do need a lawyer, but you need a lawyer who's versed in the particular facts of your case. A little earlier we had somebody talking about, for instance, a workers' compensation injury. Again, 540-0580 if you've got a question. They were talking about, the particulars and how the arm was broke and shorter and all that sort of thing. And the answer is those are all facts that are particular to the case. So I can think of a time I had two cases with two women who both fell. One tripped in a parking lot, and one tripped on a sidewalk construction site. They both broke their wrist in almost exactly the same way. They both had external fixators, the exact same course of treatment. One of them recovered very rapidly and was back to work, I think, in 6 or 8 weeks after the fixator was off, doing things with her hands. And they were both dominant hand injuries, which is also something to consider. The other lady's hand never got better. In fact, she had some nerve damage, and it caused the hand to atrophy over time. And the point is, those were two identical legal cases for all intensive purposes, all the way up and until the recoveries turned out so differently. And that's just a good example how if I had talked to either one of them at any point in the case up and until the two diagnoses, so from the time of the injury till the fixator's removed till we're 2 months out, there's not much difference in either person's case. And as you can see, the advice would change later as to what's a reasonable settlement value. And most interesting, there's another overlay on that case, which was in the one case for the gal who healed really well, liability was really clear. For the gal who didn't heal really well, she probably should have got a lot more money. She still gotten hundreds of thousands, but she should have got a lot more money because of what happened to her hand. But liability was a little dicey, and a settlement was in everybody's best interest because the insurance company didn't want to pay out all the money that they might have to, and at the same time, we wouldn't run a risk nothing for a person who lost their use of their dominant hand for all intensive purposes. So again, just very poignant thing here when you're listening to these cases. I make sure you're not just applying this advice to your own life without checking with me first or another licensed attorney here in the state of Pennsylvania, because you're going to find out that much of what we do is very fact specific to a case. I see this one quite a bit when I'm sitting in court with a client who has a third offense DUI, and they have to go to jail for a year, which is not always a good thing. And then somebody else is up there for a third offense DUI, and they're going to jail for 90 days, and the client's punching me in the shoulder, asking me how can that be. And I say to the client, you're not paying attention. I bet you if we get up there, we'll find out that you are a third for mandatory. He's a third for lifetime, second for mandatory sentencing, and that's what difference between the 90 and the 30. Or his BAC was lower than yours, and that's why he's the 90-day. So there's a lot of factors that are different in cases, so just remember what you hear on the street isn't always the way it is. Cheryl.
Hello.
Yes.
Hi, Carl.
How are you?
Good. Hey, I got a question. I have a lawsuit against someone who I lent money to start a business.
Okay.
And the business failed. They sold the business, but, not for much money. But anyway, I have a judgment against them. The judgment was entered in Maryland.
Okay.
And it, my attorney here is in the process of hiring an attorney for me in Maryland to actually collect the judgment.
Right.
And I'm wondering, he said that the guy was charging 40%. Is that pretty much a customary thing? I saw a thing in a magazine, like one of those entrepreneur magazines or something, and I know there's people that'll collect them for 50%.
Right.
But but those were just like Dog the Bounty Hunter type people.
Sure.
But is 40% pretty customary for an attorney?
Yeah, and I was going to say 50% in debt collection business is usually considered customary, even with an attorney, only because we already know that the person doesn't pay, right?
Yeah. Well, actually, the thing is, they have the money, and they have some money,
right?
But they don't have all of it. You know, because it was, see, what's kind of bad is there's some, what do you call it, vocal, oral agreements. Everything's not on paper.
Right.
So, you know, we'll probably really only be able to enforce, of course, the stuff that's written down.
Right. And, you know, Cheryl, let me explain it this way, too. The other reason why lawyers or other people want higher contingency fees, so if you came to see me for an auto accident, okay, we've done auto accident contingency fees as low as 15% in some circumstances, as high as 40% in others, with the typical being either 25% or a third, okay?
Okay.
But there, I know you're hurt. I know we're going to collect money. It's just a question of how much, so I can go with a lower rate. When it's a judgment against a creditor, or I should say a debtor, and I go to execute it, even if I know they have some money, they may still slip away by filing a bankruptcy or doing something else. So for those reasons, I want a higher percentage of return because across 1,000 cases, I'm not going to get 40% every time. In fact, sometimes I'm going to get 0%.
Okay.
So that's not. It doesn't seem like an long answer, right, to a very simple question. It doesn't seem like an unfair rate.
Well, no, it just the thing is, you know, because it's like a home equity thing, and it's going to, you know, cut in. It's like I'm going to end up with like 1/3 of the payment, but I guess that's better than nothing.
That's right. Bird in hand, worth two in bush.
Yep. Thank you, wise man.
All right.
Okay. Bye-bye.
540-0580. I'll see you after the break. Hey, welcome back. 540-0580. Carl Rominger answering your legal questions here on the air. Well, what do you want to know? You got a divorce? You want to get rid of that spouse? Maybe you want to keep that spouse. Maybe you want to know about mandatory counseling and how that works in a divorce. I tell you what, it doesn't work unless somebody actually wants it, but I've seen it work. Bobby, you're on the air.
Oh, hi, Carl. I enjoy the program.
Thank you very much.
And my question has to do with tenant-landlord. I am the tenant. I rented a carriage house here in Chester County, March 2010. It was a month-to-month lease.
Okay.
And landlord lived in the big house, and I lived in the carriage house. Anyway, I paid my rent for March 11th, and a few days later, my tenant had a heart attack and died. And his daughter became executrix, I guess.
Okay.
Anyway, they said, well, you can stay here for a while or whatever. We may sell the property. And I said, well, I'm month-to-month rent anyway. Anyhow, when I went to pay the rent, first of all, in April, she had me pay the rent to her, which I thought was really weird, not to the estate, but to her. So I said, okay. So I paid $1,100 to her. And in the middle of April, I said, listen, I think I'm going to leave the middle of May. Is that okay? The 15th. She said yes, which would be 1 month from the time I told her. The beginning of May, I contacted her, and I said, could I stay until the end because I'm having trouble getting into my new house? And she said, no, you have to leave. So I said, all right. So I do leave, but I paid for the whole month of May. I paid the $1,100 in May, not $550.
Right.
I do leave on May 15th, and I didn't hear anything from her in terms of my security or anything. I did leave her a note when I left, and I said, I see the carpet is somewhat dirty. If you need professional cleaning, take that off my security.
Mm-hmm.
So about 2 days before the 15th of June, I contact her, and she answers me with a note that says, oh, I knew I should get back to you. No, we really owe you that $550. You'll get it at the end of the month. And as far as the security goes, we bought a new carpet, and we cleaned the apartment, and we're not giving it back to you.
Well, on the security deposit, I can tell you, first of all, that cleaning, as long as you leave the apartment broom clean, wear and tear and other normal scuffs and cleaning type issues, or even just giving it that shine for showing, is not a damage that you can collect.
Right. It was in very good condition, except for that, the area that I said that I was willing to pay something on. But she didn't even give me an accounting. She didn't give me anything.
She's supposed to give you an accounting of that. Now, the fact that did she give you within 30 days in writing?
She didn't give me anything.
So you have the right to sue her for double the security deposit back under the landlord-tenant law.
I do in Pennsylvania?
Yes.
She only answered a couple of days ago. Maybe I'm repeating myself. She said she would send me the $550, which was the half month rent later sometime, very
Right.
nonchalant. And she said, as far as the other money goes, well, we just use that for cleaning. And I thought, that's not right.
Right.
Should I write her again, or should I go to magistrate's court, or what would you suggest?
I'd just go to magistrate's court at this point. I mean, if you want to settle it after that, meaning, you don't have to always follow through with getting the judgment, but you've just got to get the timeline going here, because what will happen is if you just wait and she never sends it, then you're going to go to court anyhow. If you put a little fire under the pan, you might get action sooner.
And it would be, as I understand you, it would be the double in the state of Pennsylvania.
Yes, there's a Landlord-Tenant Act. In fact, if you go to weekendappointment.com, we have that Landlord-Tenant Act up on there somewhere in one of the posts under the real estate section.
So I'm in a pretty good situation here
for
getting this.
I think so.
Yeah. Thanks a lot.
All right, Bobby, good luck. 540-0580. The short answer is if you're a landlord or you're a tenant, you need to know this. When somebody moves out of an apartment, they have a duty to give a forwarding address. If there's no forwarding address, then the landlord doesn't have to send anything to anywhere because they don't know where to send it. But you as the tenant should leave the forwarding address, and the one fight we usually get into is what's the proof. The landlord says, they didn't give me a forwarding address. The tenant says, yes, I did. The judge kind of scratches their head and says, who am I going to believe, and tries to figure it out and goes from there. So if you're the tenant or the landlord, it's good to document what you're doing. So the tenant, when you leave, you make sure you give a forwarding address, and you make sure you have the landlord either sign for it or send it in a way, return receipt requested, etc., so it's clear they have it. You then, as the landlord, have 30 days to send back itemized statement of why you're withholding, if any, the security deposit. Keep in mind that scuff mark on the wall or that wear and tear on the 10-year, you get a 10-year carpet and you had a tenant in there for 8 years. The fact that the carpet needs to be replaced is not the tenant's problem. So keep that in mind. Come up with a fair withholding, or withhold the whole thing if appropriate, and then you can document what you've done, return the money, and as long as you do that, you're not going to be responsible for it. If you don't do that as a landlord, they can sue you for double damages on the security deposit, even if theoretically they did damage the apartment. And I've had this case go down a couple different ways, and I can tell you it never works out very nicely for either side when they haven't documented things. Howard, you're on the air.
Yes. Yes, sir.
What's going on?
Okay, my car was in a flood, and it's a new car, and I went down to the dealer and I bought another one just like it, and I traded the flooded car in, which they knew it was totaled. And after the deal was done, a week afterwards, the dealer called me up and says, we're going to take your trade out of the deal, and you owe us $16,000. And I said, well, what do you mean? He said, well, when you traded the car, it was more valuable because it was able to be fixed. And now your insurance company totaled the car, so it's only worth a little bit of money, and and we have the right to do this, and you owe us $16,000.
I don't know. So what you're saying is, was there an open insurance claim at the time you traded it?
See, I owned the car,
Okay.
and it was flooded, and they towed it in. I mean, the water was up over the dashboard, and it's a new car.
Right.
And I mean, it was even on TV. And I traded it in, and they gave me like $15,000 or something for it. And I gave them the difference in cash and bought another one exactly like it the same day it was in the accident.
Right.
Okay, so then they called me up like a week later, and they said your insurance company was by and totaled your car. And I said, so? And they said, well, we're taking the car out of the deal because it's only worth a couple $1,000 now. It's not worth what we paid you for it, and you have to pay us or we're going to sue you.
I think you have a defensible position. I'd have to really do a little studying on this as to what. But let me explain it this way: if you roll in, and give me a car, and I accept it as is, and I was aware of the situation, right?
Yes.
Wouldn't I be the one sort of assuming the risk of what the insurance company is going to do? Shouldn't the dealership have been smart enough to say, particularly because they're the experts, that this car is either worth a lot or a little, depending on what happens next with it?
Yeah, I didn't know what to do, so I checked out the law library, and there's some kind of a law that they put in after Katrina or something in New Orleans.
Right.
Where because all the market was flooded with these cars that were flooded, and people were selling them. He said that the law says that the owner of the car, which is me because there's no encumbrance on it, the insurance company backed out of it and wrote me a check and said, you've already traded it. We're taking $3,000 off for the scrap.
Right.
And they said, you have to go to PennDOT and get a
reconstructed title.
Some kind of a different title, that I'm supposed to do that. And I traded it with a clear title like it was nothing wrong with it. So now I'm responsible, and I have to go get this other title in order to get rid of the car.
I don't know about that. The answer there, but I'm trying to figure this out, is were they aware that the car was flooded when they took it?
Oh, water was up over the dashboard, and it's set in a hot heat. There was 3 kinds of mold growing all over the inside of it.
Right.
And the body shop man says it's definitely total, and the insurance company took one look at it and wrote me a check for the money and took off a couple thousand for the scrap. And this is a major car dealer. It's not, it's a major Chevrolet dealer. It's not like
well, here's the next question. That you said the insurance company wrote you a check.
Right, because I owned the car, and I sold the car for $15,000 something, about $16,000.
Right.
And to them as is, and then I got the check back because it was my car, and I took the $10,000 out of my check to buy the new car and kept the rest of the money. And why shouldn't I? Because they bought the car for the $15,000 as is, and I said, why are you doing that? It's junk. And they said, well, we think we can fix it.
Well, there you go. So they had the benefit of the contract or the bargain. They were assuming the risk, so you should be able to walk from the transaction, and if they sue you, defend on that basis. Now, that's kind of a complex issue, though, for me to give you 100% advice, but my position would be don't spend the money for the moment. Hold on to it, and then decide whether you're going to compromise with them, wait to see if they sue you, or let them sue you and then defend.
Yeah.
Just because somebody sues you doesn't mean they're going to win, okay? I go through this conversation every day. Mr. Rominger, I can't believe that they sued me. It's all a pack of lies. And I say, I understand that. They're still allowed to file it at the courthouse. Now you got to go explain it to the judge.
I just never heard of such a thing. And, they're saying that they've been through this before, and it's, they'll win. And I don't know.
Well,
they said because of this new law, I am responsible to trade in a car with the proper title.
Well, Howard, so they just suddenly figured this out after they didn't like the swing on the business, right?
Yeah, I've got the title to the new car that I have, and they said you can come pick up your car. We don't want it. We want the money. Well,
Howard, let me ask you this question. Do you think they would have invoked this rule that they're claiming exists, that I don't even know exists, but let's assume for a minute that it does? Do you think they would have invoked it if the insurance company had swung the other direction and they thought they were going to make more money? The answer is no. So short answer is I think that you would be well advised to spend some of that money you've made or retained or whatever on a lawyer to do a in-depth legal analysis and tell you what are your odds of winning or losing a lawsuit in this case. And if your odds of winning are very good, tell them to go pound sand. And if your odds of winning are poor, then consider a more graceful exit. But I can't answer that question 100% here on the air. We'd have to do a few hours of research, my friend.
Yeah, I told him he can buy a lot of lawyer for $15,000.
That's right. All right, man.
I thought it was an interesting case.
It is interesting, actually. 540-0580. I'll see you after the break. Rominger answering your legal questions here live on the air here on WHP 580. 540-0580. Call in. We'll answer them right now. Carol. Hey, Carol.
Hey, how are you, Carl?
Good.
I'm considering renting a vacation home through an LLC that does not use a written rental agreement.
Okay.
And notwithstanding that, am I correct in assuming that practice would inure to my benefit, notwithstanding the fact that there's no cancellation clause that I could go to?
Okay. Back up here for a second.
Okay.
So you're going to rent the vacation home?
Rent the vacation home.
Okay. And there's no cancellation clause?
Well, there's no written agreement, period.
Okay.
What they want is a credit card to charge the quoted rates against. That's it.
And that's it?
That's it.
Well, I guess the short answer is if you let them charge the credit card, they get the money.
Right.
I guess you could dispute it later, right?
Right. Well, that would be the question, because since there's no cancellation clause, I'm not sure.
Right, and that's usually where, if there's nothing in writing, I think the cardholder agreement controls, and both of you should have terms with your card, meaning they have terms for accepting them, you have terms for using them. But it seemed to me a few years back that some businesses were actually having people sign something that said, I realize there's no refunds or returns on this. And that way, if you did dispute it, they could give that to the credit card company to make it clear that you'd already agreed that even if you didn't get the vacation home for some reason, like you canceled it or couldn't go, that you couldn't just reverse the charge on that basis.
Do you find that unusual?
That they're not getting anything in writing?
Right.
I do find it a little unusual they're not getting anything in writing.
Is that a red flag?
Are you dealing with a realtor?
Dealing with a family-owned, not a realtor, no, but a family-owned company that handles, I think, the property management of rental homes, of vacation homes.
The short answer is I do find it a little odd that they don't have anything for you to sign. I mean, are you supposed to just sign something when you get there that says I won't take the silverware either?
Well,
or
no, what they're asking me to do is send my name, address, telephone number, and my credit card number to them via email, and that is going to be my reservation.
Okay. So they're going to use the email as the writing.
As the writing.
But they don't have any package of terms for you? Are they going to send you something, or do they have on a website?
No.
Yeah.
No. So the only thing that I can think to protect myself is anything that I put in this email, or any terms that I would want, such as a cancellation term, to put in the email. And if they don't accept it, then fine. But that would be it. That email would be my terms and conditions.
And you know what? I mean, in this day and age, using emails or even Facebook posts, I guess, to create contracts is not unheard of. I'm just a little concerned that if they're a professional property management, that they don't have a standard form of something or the rules of the road for our properties, or just a brochure or something that says, here's our expectations and your expectations. But maybe you check them out. Have you tried Googling them and seeing how?
I've Googled them. I've called. They seem legitimate. They do seem legitimate. I was just hoping that if you could think of anything that I could do to protect because we will probably move forward, because they do indeed seem like a legitimate company.
Right. Yeah, and if other people have had good experience with them, I mean, the short answer is not everybody does business exactly the same way. And maybe it would be a problem, maybe it wouldn't be. But I can't imagine, like you said, does this raise a flag? It raises a little bit of a flag. But if there's other things that give you comfort, what's the worst thing that happens? I guess you go out there for a vacation home and it's not there.
Okay, then I'll be seeing you.
And then you're going to go get the Motel 6.
All right,
They'll have a light on for you, Carol. All right.
All right, thanks a lot.
540-0580. Carl Rominger here at WHP 580. What else has been going on in the legal world lately? Well, the Supreme Court's sitting on an opinion or two right now. I know there's eminently supposed to be deciding some cases, so keep your eyes peeled for what the U.S. Supreme Court's up to. The governor, I believe, banned bath salts. Did he sign that bill? Shane's kind of sad, it looks like. I don't know why he's so upset about that. And the short answer is, I saw in the newspaper the other day, they're saying, oh, well, these bath salts and marijuana could be driving up these drug-based DUIs. That's not true at all. What's driving up the drug-based DUIs is 10 years ago, or even 5 years ago, or even 2 years ago, when the state police pulled somebody over driving erratically and they didn't have alcohol in their blood. If they happened to have some marijuana in their blood, or if they had some Xanax in their blood and they were dumb enough to admit what they were on, they could get them for a DUI by drug. But officers weren't testing for drugs. The protocols weren't good. There's no uptick in driving under the influence of drugs. There's just an uptick in the ability of law enforcement to figure out what you're on. So long and short of it, despite what people are claiming that somehow this synthetic marijuana or bath salts or other drugs are driving up drug-based DUIs, the answer is law enforcement is just getting better at catching them. So the ones that went unprosecuted for so many years are now lining the pockets of the counties and everybody else with money. David.
Yes.
What's going on?
Hey, not much. I was just happened to be listening, and we own one of those vacation rentals.
Yes.
And the caller you just had was an interesting question because we don't do any written contracts either on our end as the rental owner, because a lot of the people that we're renting to are middle class, good-willed Americans, and it's just a lot of bother and red tape for a weekend or a week's stay. We don't take all their money up front. We just ask for a down payment, and then they pay the balance when they arrive.
Okay. I appreciate that.
I wouldn't be too worried if I were her, as long as the reviews are legitimate. Because it's usually a lot of times it's just an owner-operator on the other end.
Got it.
They're just doing it as a side thing, or
right. So this isn't their primary. This isn't their primary thing. That makes good. That makes sense, and that's why I said if it raised a flag for her, but other things calm her down, why not?
Right.
That's the other reason why if you check them out and other people have used them, why not?
Right. I mean, and frankly, on our end, we've found over the years that the customer like herself, who needs every I dotted and T crossed, is actually a major concern for me, because they're usually the ones that complain about every little thing or
got it.
That, or seriously, if she were my client, I would walk away from her.
Got it.
When
all right.
they start getting all worried about it.
All right, brother. I got to make an announcement here, and then I'm going to run out of time.
Take care.
Listen, folks, we're going to do a live show. It's tentatively scheduled for July 16th. We're going to do it at 1000 Prince Street in Lancaster. You'll be able to attend if you want. So if you ever want to see how a radio broadcast works, well, you won't be in studio, but we'll be doing it live from my office down in Lancaster, which is co-located with Caldwell Banker Select Professionals. And those guys are going to be on hand to answer real estate questions as well. So we're going to have some food. We're going to have the live radio broadcast. You'll be able to ask questions live in person if you want. We can probably still take phone calls. And we're doing that on July 16th, I'm told. Now, the backup date's July 23rd, I think, but I don't think that's actually going to happen. So it should be July 16th. So mark your calendar, and if you want to come live, you're invited to come on down. It's going to be in Lancaster, 1000 North Prince Street on the 16th of July. So get ready for that Saturday afternoon. And like I said, we'll have some tasty treats there. In the meantime, as always, if you need a lawyer, go to romingerlaw.com or weekendappointment.com. Feel free to contact us. We have offices in Lancaster, Chambersburg, Harrisburg, Carlisle. We travel all through the mid-state. Happy to help you. See you next week.